Welcome to Limits Exhausted, Texas's personal injury litigation podcast.
Hey everyone, welcome into an all-new episode of Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, the founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. I'm your host, Mike Leon. Kiernan has served as lead counsel in more than 40 trials and frequently handles complex, high-damage cases involving 18-wheelers, industrial incidents, traumatic brain injuries, wrongful death cases. Today's episode, we're going to be talking about catastrophic injuries specifically. Kieran's going to explain what lifetime medical needs really look like, how they're proven, and why these cases require a level of depth that many attorneys don't encounter in their routine personal injury litigation. Kiernan, it's good to see you as always. When another attorney sends you one of these cases that I just mentioned, these catastrophic injuries, what are some of the first indicators that the long-term medical picture will be a central part of the litigation?
Thanks for having me, Mike. I appreciate it. Yeah, so one thing that we got to get to grips with at the very beginning here is that future damages, such as future medical care expenses, are usually one of the most, if not the most, controversial parts of a case. The defense, the insurance companies, if we're claiming future damages, they're defending against it. It's a very one-size-fits-all approach that they take. Now, they might use different tools for different cases to defend against futures, but if futures are being claimed, they're contesting it. What I do and what we do in our practice is we don't do it like the insurance company does. We don't take a one-size-fits-all approach. We use individualized assessment of cases to see where a victim is really at with their injuries, how far along they are, and what they need based on what's actually going on with them. So different cases require different types of workup. For example, medical literature is very clear that a person who has a soft tissue sprain or a strain, like sprained ligament or strained joint, the human body is going to heal that injury on its own without treatment in about 4 to 12 weeks. And in an extreme case, it might take 4 to 6 months. But the body is going to heal a relatively minor soft tissue injury on its own without much intervention over the course of a series of weeks or months. So if I get a case that's referred to me that's 6 or more months old, where we have somebody who's continuing to have symptoms that show that their condition has gotten worse or it's flatlined and it hasn't improved, if they're experiencing symptoms long after the date of the incident, that's a red flag that this person has a more serious and more permanent injury. So we try to go deep with the client and understanding what their conditions are and have them see appropriate specialists. Recently settled a case that had about $6,000 worth of medical bills for mid-six figures in a workplace injury case because we were able to identify an area that the doctors that had been treating him up to the point that I got the case were under-treating him. By getting him to the right kind of doctors who were able to give him a more comprehensive assessment of those injuries, we were able to add a ton of value to the case. So we really want to get in touch with what is actually happening with the client and see what they need and kind of go from there.
It funnels into a follow-up beautifully, Kiernan. Like, staying with that example or even using a different one, like how do you evaluate the difference in the immediate medical records and that long-term functional limitations that they may have that maybe won't show up until later on? Like, how do you balance that?
I'm going to be a little bit of a broken record on this one point. I think I've said it before on the podcast. I'm probably going to say it a couple more times after today. Doctors' job is to treat patients on a visit-by-visit basis. Doctors will sometimes have treatment plans that involve treatment over the course of a couple of months. Like if they think somebody could need a surgery, that might be in the plan in terms of something that they're considering for the patient. And they might have a plan, but it would typically last only the course of a couple of months. Doctors are generally treating people like as they find them as they present right in front of them without too much of a long-term perspective. So generally speaking, what we got to do with these cases is we got to get a full clinical picture. We got to make sure that everything has been diagnosed that's going to be diagnosed, and the person has tried, like the victim has tried some fairly serious treatment for it, and we see how they respond to that. And if they're continuing to have symptoms over a longer term, that is when we want to consider things like a life care plan. Now, for people who don't know, who don't swim in these waters of personal injury litigation, a life care plan is a model, or it's a projection of what treatment somebody's going to need for injuries related to a specific event as a ongoing treatment for that injury when those injuries aren't just going to resolve. Like, just because you're in a trial doesn't mean that everything bad related to your injuries has already happened to you. It's very common for somebody who has like a fusion surgery, for example, where they put in titanium rods and screws and plates into somebody's spine in order to fix a disc problem. That person's a lot more likely to develop something called adjacent segment disease, or ASD. And when somebody has ASD, it's a lot more likely that they're going to need a fusion at an adjacent level of their spine in the future. So there's certain conditions that are red flags for the need for a long-term care model. So we look for those things, and we don't want to rush getting a life care plan. Like, we don't rush into long-term care. Like, not every case is going to get a long-term care model, but the cases that do deserve it, and the cases that do require it, we do need to do it. And we got to make sure that the experts have as much information as they need to form reliable opinions when we ask them to do so.
Kiernan, can you kind of walk us through a past case of yours where this kind of lifetime need analysis that you were just mentioning, it kind of changed how the case was ultimately valued or even tried?
Yeah, I mean, it's hard for me to come up with a specific example of this because, I mean, I've had hundreds of cases that had future care models from life care planners, or otherwise had, future projected treatment or future loss of earning capacity. I mean, I would say that cases that have a future earning capacity loss as well as future medical loss, those can really change what a case is valued at, because one thing we know is that insurance companies can be a little bit hidebound, a little bit black and white. If it's not documented, it doesn't exist to them. That's kind of their attitude. So damages that can be quantified in dollars and cents, whether it's medical bills or whether it's earning capacity, those tend to have a bigger impact on what a insurance company values the case at than something that's a little bit more intangible, like pain and suffering or impairment. Not that pain and suffering or impairment are a smaller deal. In my opinion, they're a bigger deal, but it's just easier to get the insurance company to put a fair value on economic damages, even though, like I said earlier, future damages are usually, if not always, going to be contested, whatever they are, regardless of the case. Even if somebody has, quadriplegia or something, they're going to contest what the care is recommended by a life care planner. So we don't want to take a one-size-fits-all approach like the insurance company does.
Yeah.
We look at these cases, and if the case requires it, age can be a factor. The victim's age can be a factor in determining what kind of life care plan they need, or if they need one, or what type of future care will present. And these things make a huge difference in cases. It can often make the difference of, hundreds of thousands, if not millions of dollars in terms of what the case ultimately is valued at. So it's hard for me to point to a very specific case because it's just a regular part of my practice.
Yeah. Well, let's piggyback on that because you mentioned the insurance carrier. So how do they typically respond when they realize now that the future care component of the case is a little bit larger than the initial presentation of the case suggested?
Well, I mean, for one thing, I always try to present cases to the insurance company as serious as I can possibly present it at any point in time, simply because I know that the cases that end up getting litigated that don't settle quickly, those are cases where it'll often come out that the person does need a longer term model for care. So I don't think it really surprises them. Oftentimes, like disclosure or turnover of documents related to long-term care happens around litigation deadlines, like an expert designation deadline. So, these things will typically come out at some point during litigation. And one of the things is that it's important not to try to rush to get a life care plan for somebody who might need one early on in the case, just so the insurance company realizes how serious the case is immediately, because the life care planner really needs a lot of information. Like the more information that they have and the fuller the person's clinical picture is, the more information there is about how they're responding to treatment, what kind of treatment doctors are recommending, what's working, what's not, how long these like symptoms are lasting. Like, it's kind of hard to really arrive at a very, very firm permanent injury diagnosis within the first 2 to 3 months of the case, which is often when it'll first be presented to an insurance carrier. So I think they're often seeing this a little bit later on into a case, and I think that they come to expect it. And the bottom line is that, as I've been saying, they always contest future damages. It's just going to be, if they're being claimed, they will be contested. They might contest them in different ways. There's different tools they use. One thing they do is that the approach I described, sort of grading the homework, where they don't really try to say this person isn't injured, or they don't say that they don't need future care. What they do is they just dissect the medical records and just dissect the life care plan and say these, records didn't connect the treatment with a sufficient explanation, or there was, stuff with the documents that they can find fault with, or they think this treatment should have been done instead of that treatment. And that they'll just kind of try to, nitpick and grade the homework and then argue to the jury that they didn't prove it, the plaintiff didn't prove it. And there's different approaches that they can take, but there's the one thing we know for sure is that if there's future damages, it's going to be contested. I've never tried a case where the defendant stood up in closing argument and said, you're right, this person's going to need futures. Here's what, they need, instead of what the plaintiff's advocating. They don't do that, really.
Yeah. Well, let me ask you, as you're preparing for these catastrophic, injury cases for trial, let's talk about the juries. What are some elements of what we've been talking about with the life care evidence? Like what tends to be the most persuasive that you have found to juries?
Right. So there's a saying on the defense side that if you're defending against everything, you're defending against nothing. What comes out during discovery is we learn what exactly they're going to take issue with. They're not necessarily going to take issue with everything. They'll usually have a couple of points that they're going to hang their hat on. And depending on what's being argued, different evidence is persuasive. Like, for example, if we have a case where they're trying to claim this person wasn't injured at all, no injuries, that it's all bogus, you see that. And in those cases, one of the most effective kinds of evidence is going to be having the treating surgeon or having a radiologist or neurologist put images of the plaintiff's MRI film on the projector and show the jury, like, that is the injury. That is the herniation. That's where the nerve compression is happening. Seeing is believing. When you can show them the injury in a photograph from the MRI film, it makes it a lot harder to say that there's nothing to see here. When it's a case that's more about, what does the person need? How hurt are they? It's more about severity rather than the black, white, yes, no. In those cases, what I find is very important is that the jury gets context for what the life care planner is actually trying to do. Like, I've heard stories about life care planners in some cases who got a little bit carried away, where they included things like, a swimming pool for the victim's home so they can do home aquatherapy, things like that. It can start to look a little bit like a wish list or a Christmas list of everything that they might need or that they might like to have to address their condition, when in reality, what I try to show the jury is everything that the life care planner considered but didn't include, so that the jury understands that the life care plan isn't some sort of aspirational wish list. It's a very solid projection of what the minimum that they're going to need, at least long-term, to care for their injuries.
Kiernan, as we wrap on today's episode, what should the referring lawyers out there understand about how these cases evolve over time when the long-term needs continue to change while this litigation is still underway?
Right. So what I would say is that, I've got a couple of things to say about this one. The first thing is that it's really important to have good client communication, because you'll know through communication with the client who's really, really struggling, who is having ongoing problems, who is being diligent about following up with their doctors, but isn't getting that much relief. Like, you will kind of know who's got it bad, who's down bad and needs help. Clients like that, even if they haven't done a ton of treatment, will often have cases that need to be worked up a lot for the case to really get to the point where the lawyers are able to present, to the jury, to the insurance company, this is a fair and reasonable value for all of the person's harms and losses, where we're really getting into everything. We're showing the full picture. Those things take time, but if you've got a case that has a good amount of limits to play with, and that just has some risk exposure to the defendant, if somebody has got a lot of problems, that could be a really good case to refer out early, because those are the kind of cases that we can really do a lot with in terms of eliciting all of their problems and getting the doctors to making sure they see the right doctors and making sure they have a future care model and things like that. So that's really important, is just knowing who's got the most serious injuries that need this stuff. Additionally, it's generally something that's going to happen during the litigation process. Like, there's often some discovery that we want to do before we make a final decision about whether or not we want to bring in a bunch of experts to talk about damages. I mean, some cases are just going to scream at you from the beginning that the person needs it. But other cases, it's going to be a little bit more of a judgment call based on the progression of the case. So having somebody who's experienced and good at evaluating these cases, look at the case and work up the case, you can have confidence that they're going to bring in the right experts at the right time in the right case to get the maximum bang for the buck for the client, and make sure that they're taken care of and that they get a settlement that's actually fair and reasonable and commensurate with what they actually need for the long term. So I'd say that just having the case go to somebody that can evaluate when these things are needed is very important. And I would also say just that these are often the most contentious cases. It's a bit counterintuitive. You might think that the insurance company is going to pay off the really big cases and fight over the smaller cases that they don't think are amount to that much. And sometimes that happens, but generally speaking, it's more of a business decision for the insurance company rather than like a humane or humanitarian decision where they're deciding who's really a deserving claimant, who's less deserving. That's not what they're doing. They're making the decision based on what their monetary exposure is. So the more injured somebody is and the more problems they have and the more problems that they're going to have in the future, and the less that short-term care is going to solve their problems, the more contentious and hard-fought the case is ultimately going to be. So those cases are ultimately going to be the ones that get litigated, and they need to be litigated by people that do litigation and that handle those kind of cases all the time and understand how to maximize case value and make a compelling presentation to the jury for the full range of the damages, and can effectively elicit a full compensation verdict from a jury. So it's important to know that, like I said in past episodes, they handle small cases real differently than they handle the big cases. And the big cases are the ones that get fought over, not the smaller ones a lot of times, which is one of the things that is a little bit counterintuitive. But, having effective, experienced, proven trial counsel work on these bigger cases is going to pay dividends, because those are the cases that ultimately require that.
Yeah. Kiernan, thanks again for the time, the insights, breaking this all down for the audience, man. I appreciate it.
Absolutely. You bet, Mike.
That's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. If you want to connect with Kiernan, you want to check out more of his work, do me a favor right now, visit McAlpinelaw.com. Thank you again for listening. But before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.